I was not able to lay the foundation of the introduction of the Facebook through Maynard, and so we did not do it. So we marked it, I think, in the envelope, but this man can introduce it because he was in charge of Intel at that time. So I want to ask him about that, lay the foundation, and get that.
Okay, so this is the conversation with
This is all.
Jarvis Middleton.
No, this is all of the Facebook, the packet, all of the packet. Okay, because I want to pull sheets out of that packet to talk about. So I have to get it in evidence. I just can't pull. I could pull one sheet out and start talking about it. I don't want the jury to see the entire Facebook, but I've got it on a thumb drive.
Why can't we just do it piecemeal, one by one, as to what you want to do?
Oh, that's fine with me.
I think that's probably more appropriate.
Okay, that's fine with me.
And I know that.
Do you want to see what I'm talking about?
Well, is this what we've already looked at with the conversation with Mr. Middleton? Okay, right.
And Maynard issue.
Okay, and you renewing your objections as to, go ahead.
In addition, I mean, he's not the person who did the cell bright on his phone. That's Sisson. He can't lay a foundation for how the cell bright was done. Sisson did the cell bright. He pulled it. He got the information off the phone. Then they had to put it in the cell bright. This officer knows nothing about this phone. He didn't collect his phone. He didn't pull any data off his phone. Just because you work in an department doesn't make you certified talking about it. In addition, this conversation between Sarah and we assume to be Jarvis Middleton, it's not even admissible because Jarvis Middleton's not even testifying. It's a right to confrontation to cross-examine witnesses. You can't say, well, this conversation between Sarah and Jarvis Middleton about this Maynard situation. And there's even any relevance. So I think the Constitution's denial of finding a fair trial. We're not allowed to effectively cross-examine any witnesses. It is not relevant for the central issue of whether she engaged in a riot or not.
I mean, I'm trying to, I'm just reviewing what's in front of me. It's the communication, it appears to be on June the 2nd, with regard to Police Chief Maynard and Jarvis Middleton, about,
It's with
whether
Sarah.
or not
It's
that
with
they
Sarah.
assisted.
It's with Sarah.
It was Sarah, right? Jarvis
Right.
Middleton and Sarah Williams. And it involves sort of cooperating with, I guess, the police or their demands to reach out to the police. I introduced evidence, I think, with regard to previous statements that she had made, especially with regard to intent plan preparation to escalate matters. We've already had testimony as to, her unwillingness to cooperate with the police. I mean, it's already been testified to. I'm not sure if I understand the relevance of this because temporarily doesn't have anything to do with escalation. It doesn't have anything to do with, amping up or, the underlying charges. It just says I'm being, be disagreeable with police.
Okay, it's corroborative evidence of the statements because he's arguing that statement isn't true or you can't believe him or whatever. This corroborates the statements, Judge.
I haven't made any arguments about any statements. I'm saying,
and this also talks. I'm a little bit worried because also it involves, a discussion of disciplinary actions regarding the chaplain.
Well, I can take that part. I'm not interested in. I'm talking about the one that it's documented that we have. We can excise everything else out. I'm just showing the pages. I don't want to excise it now. I want everybody to see it. And I don't want to get the other stuff in there. I just want those things that are highlighted because that's her statement. That's like making a physical statement about this case.
true, but it's coming from Facebook.
And it shows her intent, clearly.
Well, and that's what I'm wondering about. Are you seeking to just prove the intent not to cooperate? Because the intent not to cooperate is really not, I don't find that to be significantly relevant to the intent to ramp up the protests or to accelerate the protests. I think that's extremely relevant. I'm worried that we're going down a road of accumulation of evidence and really some things that may confuse the jurors.
Well, okay, we have had proof presented that the police department was unable to determine where they were going to march, and so they had to go out to try to intercept it, and that caused problems with the community or whatever.
And you've already got in the fact that she has said that she, wasn't cooperating with the police.
She hasn't said that.
Well, I mean, not that she hadn't said that, but the police officers had already testified that she didn't cooperate, so.
Well, two did, but they're basic statements that, he's going to pick apart and try to say there's nothing to corroborate that. They didn't write a report. You remember? He said he didn't write a report. This is a statement from her on this issue.
It is, but I don't find it, again, the ultimate issue is whether or not she incited a riot. And temporarily, this happened on June the 2nd of 2020. This is a whole, at least 10 days in advance of the actual alleged criminal activity, and it doesn't really talk about escalating. It just talks about, the fact that she wasn't cooperative, and you can establish that through other officers. So I think that...
Do you think that it's
I think
prejudicial to the
prejudicial
defendant?
to her. Yeah, I do.
Why?
I think it's prejudicial because it's offering some sort of, I think it's proliferating the issues.
Okay.
About
All right.
Chaplain Donovan.
That's not what I'm trying to get
I don't think
into.
it's temporarily relative.
I'm not trying to get that in.
Yeah. So,
Okay. All right.
we're back on the record. We got the